The animals had the freedom to go around the house, yet he was the one that was locked in that box. The state never made any allegations that he was in there 24/7. The state never said that he had never left his room. He did. The only time he left his room was when there was a parent around. When they told him, you're allowed to come out. It was not reasonable to lock him in a box. It was not reasonable to leave him in the dark. It was not reasonable to leave him in the room with no air conditioning. It was not reasonable to make him pee in a bucket.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott.
And I'm Michael Ayala. We have new developments in the boy in a box case in Florida. The judge could issue his written ruling any day now on Tim Ferriter's request for a bond ahead of sentencing.
Ferriter appeared in court this time in a blue jumpsuit, fighting to be temporarily released from jail. He was seen trembling during his court appearance. Just last week, he was found guilty of child abuse and other charges for locking his adopted son in an 8x8 windowless room built in a garage, and he was locked in that room for up to 14 hours at a time.
We, the jury, find as follows. As to count one, we find the defendant guilty of aggravated child abuse as charged in the information. As to count two, we find the defendant guilty of false imprisonment as charged in the information. As to count three, we find the defendant guilty of neglect of a child as charged in the information.
Now, the judge agreed with the prosecutor that a pre-sentence release is incredibly rare, but didn't give his final decision at this point. Let's listen to some of the arguments in that hearing.
As Your Honor knows, it's an incredibly rare thing for there to be a pre-sentence release. There are very specific guidelines that dictate post-sentence release, but this type of posture is incredibly rare, and I cannot think of a case in my career where there was a pre-sentence release. The defense has articulated that he doesn't have any continuing contact with the children. That is just not true. The youngest child in this case was adopted by his co-defendant's parents, and he's had continuing contact with that child even since he's been in custody. And so there is a substantial risk, and I think it's important to note that that child was removed from his custody by the Department of Children and Families. That dependency case closed when the adoption took place. And so there's a risk even that he'll have continuing contact with a minor child or even be living in a home with a minor child. We don't know that because the defense hasn't provided any evidentiary support for where he'll be living, who he'll be willing left, and whether or not only we can prevent him from fleeing, but we can protect the community from someone who has now been convicted of multiple crimes against a child. And so based on all of that, I don't think that they've reached their evidentiary burden, but there's substantial support for the idea that he has a risk, especially in consideration in light of the bottom of the guidelines in this case in a mandatory prison sentence.
Okay. All right. Thank you. Ms. Coakley, rebuttal. Mr. White.
So I'm familiar with Kraft. The issue in terms of burden to start with is it's our burden to deal with the securing of his return to court, which is the entire purpose of bond. And we're dealing with that through the issues that we brought up as to surrendering his passport and a GPS monitor, and that he will be residing in Palm Beach County. In terms of the address, I'm happy to provide the address to the state. I'm happy to have them go and do whatever they need to do to make sure that there's no child at the house or anything of that nature. In terms of the bond amount, there's nothing in the case law that says who puts up the money. That was irrelevant. And in terms of
why is it irrelevant? Because bond is typically it creates financial exposure for the defendant putting up the bond or for his family that's putting up the bond. If he's not the one that put up the bond, why isn't that a factor I can consider in the sense that the normal scenario where the defendant would feel the financial pressure of the bond doesn't exist here if someone else has put it up?
Well, because first of all, even if as to the previous bond, this is what we're talking about, right? The $50,000 bond, sure. So clearly, he did continue to come to court on that. So the evidence in the record is that it did work. He did continue to come to court all the way through trial. So there's no issue that I don't think the state's even saying that he missed a court date. So there's no issue that that didn't work. Of course it worked. We know. We went all through the process.
Sentencing for Tim Ferriter is scheduled for November 16th. That's less than a month. And he faces 75 months, which is a little more than 6 years, to 40 years for his convictions.
Yeah, significant sentence. Joining us to discuss is criminal defense attorney and former prosecutor Franz Borghardt. And Franz, I'll just put it to you very simply. What do you think his chances are of getting some kind of relief for this motion?
Yeah, I think he's going to be staying put, Michael. I don't think a judge is going to let him out on bond. Now, look, in a vacuum, it could be said, look, this is a guy that showed up to court. This is a guy that probably has a minimal criminal record. Is society really at risk? Is there a risk of him not showing up? Probably not. So could he be granted a post-conviction bond, so to speak? Sure. He's not going to be granted a post-conviction bond. He is looking at a mandatory minimum sentence. He's probably going to get far more, I suspect, than the mandatory minimum sentence. He's probably going to stay put. And look, this is how our justice system works, is you get convicted of horrible, terrible crimes, and you go to prison sometimes. And that is the long and short of it.
And this judge, to me, did not seem like a judge who strays. He was I felt like, very experienced, very on top of things, knows what's going on. But also, let's talk about, in this case, there was a 2-year plea offer. We don't know what all the conditions or terms of that were, but we know that we were able to see and show our viewers that he said, no, thank you, I'm not accepting that plea, I'm not entering a plea. And does that factor in at all, do you think, to the court? Because it's really the judge's discretion now to determine whether or not he's going to allow him to be released.
So theoretically, Judge, as you know, you're not supposed to get a, quote, trial tax for going to trial and losing. However, that judge sat through the entire trial, has heard the facts. He's been convicted. I don't know that he's being punished now, but he's been convicted and is looking at a mandatory jail sentence. The other thing that has to be in the back of the judge's mind is there is another trial in the pipeline, and perhaps the co-defendant, seeing what's happening to her spouse, might convince her, whether it's right or wrong, that perhaps she needs to consider taking a plea or a resolution. So there's a lot of little factors. No, we're not supposed to punish people for going to trial. It happens sometimes. I don't know that this is punishment, though. This is just reality. You're looking at a mandatory minimum jail sentence. There's no good reason for him to be out during the pendency of his pre-sentence. This is normal.
You know what's interesting? The state made a very interesting argument in that area, saying, hey, look, Judge, he turned down a 2-year plea deal. So that just shows you how adverse he is to jail. Now that he's facing 6 years, I think you throw it in the pot in determining whether he's a flight risk. Now, there was an interesting argument that they made, so you can use it in that sense. I got to ask you, where do you think the judge might fall with a sentence? I got the distinct feeling from the judge that he was not happy about this case from the beginning. He didn't like the facts of this case. He's got a wide range to deal with here, 6 to 40 years. Where do you think is appropriate? Because I can tell you, this was a horrible, horrible case. But I do believe this was a man who just got the discipline wrong, very, very wrong. And a long jail sentence, I'm not sure, is the answer. Maybe treatment, maybe other things might be the answer. But anyway, I'd love to get your thoughts, Franz.
So I feel like my gut is telling me, and this is totally just gut, 10 years and some time on the back end to where maybe some of the time on the back end suspended. So maybe what we call a split sentence, right? 10 years of which he serves a certain percentage of the 10 years. That covers the mandatory minimum. That gives him a little bit additional. He won't spend the rest I don't think he's going to spend the rest of his life in jail. And I agree with you that I think this was a galactic mistake, an inexcusable mistake. But I think this guy is salvageable as a human being. And at the end of the day, I think that putting him away for 20, 30, or 40 years isn't justice. I think putting him away for a period of time, getting him some help and assistance, putting some time over his head, I think that smells more like justice to me.
And not being able to raise any more children, because I don't think he should get that privilege. That's my opinion.
So never get his children back at any
I don't
point?
think that he should be allowed to if he's there for 10 years, unless you can really show rehabilitation. But, you know, look what he did to one of his kids. I have to tell you that I do write down my prediction, and I put Timothy Ferriter so I wouldn't forget. And I, too, on the 4th of October, said 10 years. Now, we may be wrong, but Franz and I are thinking along the same lines. Yeah.